Hello friends, in the series on income tax cases today we will discuss a very important case which is regarding the raising of objections of the grounds which were not disposed of by the CIT appeal, because the assessee has given a letter to the CIT appeal that I am not pressing these grounds if the CIT appeal gives relief to the assessee on merits. The issue before the Honorable Tribunal Pune ITAT A bench was that if the assessee do not press some legal grounds on the condition that the assessee gets the relief on merits, so whether in that case if the revenue files the appeal before the tribunal against the order of the CIT appeal, so whether in that case the assessee can raise cross objection for the grounds which has not been adjudicated by the CIT appeal for the assessee not pressing them conditionally. This issue has been decided by Pune ITAT A bench in the case of Ravi Selapan versus Deputy Commissioner of Income Tax. This case is reported in 137 ITR Tribunal at page number 225 and the date of the judgment is 10th February 2026. The present case relates to the assessment year 8-9. The assessment order under section 147 read with section 143 subsection 3 was passed. Some additions were being made. The assessee was before the learned CIT appeal and the assessee has raised the legal grounds regarding the reopening of the assessment, and at the same time the assessee was contesting the case on merits also. During the appellate proceedings before the CIT appeal, the assessee gave a letter dated 19th December 2016 to the CIT appeal that if the CIT appeal gives the relief to the assessee on merits, then the assessee is not going to press the legal grounds. Since the learned CIT appeal was convinced with the merits of the case, the CIT appeal gave the relief on merits by not adjudicating the legal grounds of the assessee. The revenue filed the appeal before the tribunal. If the assessee has not foregone the legal grounds conditionally, then there was no doubt that the assessee can raise the cross objections before the tribunal for the grounds not adjudicated by the CIT appeal. But in the present case, since the grounds has not been pressed conditionally by the assessee, so the tribunal at the first hand said that since the assessee has foregone the grounds, it doesn't matter whether they are foregone conditionally or not. The tribunal said that the assessee cannot raise the cross objections, and the tribunal had given some directions without the assessee getting the opportunity to review the facts. The tribunal had not considered the assessee submissions. Against the order of the tribunal, the assessee filed miscellaneous application in the tribunal that since the assessee submission has not been considered and there is a patent error in not admitting the cross objections of the assessee simply on the context that the assessee has foregone those grounds conditionally. So when the tribunal heard the matter, the tribunal said that in the present case the miscellaneous application of the assessee should be heard and allowed, and the tribunal restored the appeal of the assessee by saying that in the present case the assessee had been granted liberty to raise all the legal and factual grounds in the revenue appeal and recalled its earlier order. Friends, this case is very important because sometimes the question arises before the appellate authority that the assessee or the revenue raises a number of the grounds and the appeal is allowed on some ground and the other grounds are not adjudicated. So there is no doubt when the other grounds are not adjudicated, the cross objections can be filed. But in the present case, the issue was very limited, that if the assessee has foregone those grounds or has not pressed those grounds conditionally, that if he gets the relief on merits, so whether in that case also the assessee can raise the cross objection. So the tribunal was with the assessee and the miscellaneous application of the assessee was admitted and the assessee was allowed to raise those grounds also which were not pressed by the assessee at the CIT appeal. At the end of this video, once again I am repeating the name of the case. The name of the case is Ravi Selapan versus Deputy Commissioner of Income Tax, and this case is reported in 137 ITR Tribunal at page number 225 and the matter has been decided by Honorable Pune ITAT A bench on 10th February 2026. Thank you, friends.